Hello, my name is Georg Huber. I'm from Austria, and I'm not giving you an update on Austrian advertising law, but rather on EU law, which affects us all, and not only the European countries, but also countries being active inside the European Union, but having their seat outside. So it's data protection and direct marketing. As you all know, by May 25th this year, the the General Data Protection Regulation will become effective. And that means we got new other standards for direct marketing, online marketing, behavioral marketing, and things like these. And just to start with, because not everyone is familiar with the GDPR, I would just give you a short outline, which means the material scope is that not only companies within the EU have to obey it, but any company outside the EU, if they offer goods or services within the EU, or if they monitor the data subject's behavior within the EU. And that is easily done. And one central term is the controller, and that's the person responsible, and that is anyone who determines the purpose and the means of the data processing. Now to go on, any data processing, the general rule is under the GDPR, any processing of personal data is prohibited unless there is an exception. And there are a few exceptions, but the main ones which are relevant here in this context are consent, if the data subject gives his or her consent, if someone has to comply with a legal obligation, if it's necessary to fill the contract with the data subject, or if the legitimate interests pursued by the processor or by the controller or a third party override the interests of the data subject. Now, this thing here, the overriding interest can sometimes be invoked in some cases of online marketing, and which means we don't need the consent. But whenever we have one of these legitimate reasons, we don't need another one. And direct marketing, as it is called also in the GDPR, could be one of such legitimate interests that is explicitly stated in recital 47 of the GDPR. But that means the interests must override the other interests, which means we have to weight interests. And this is a tricky process, and I've tried to find a few criteria now. What are the expectations of the data subject? What about transparency? Do we have minors that are data subjects? Do we pseudonymization? What are the guarantees we can offer, and things like these. Anyway, we must provide an opting out possibility for the data subject. And one rule is the interests will never, or the interests of the controller, the company, will never override the interests of the data subject if there is a profound profiling going with it. So that often happens if we do online marketing. And but let's start with the easy thing. If we simply send out newsletters, which are not based on a deep profiling, that should be permissible under the GDPR, because clients often ask, do we need a consent here? No, we don't. Maybe we have to obey telecommunication laws, like in Austria. There are some limitations, but simply sending newsletters would be still allowed. It gets a bit more complicated if we look at tracking tools or behavioral advertising. Tracking tools leads to profiling. That means we evaluate certain personal aspects, how persons behave, like on the internet, where they live, what they do, what websites they visit, and stuff like that, and try to draw conclusions out of that behavior. Now that is, for instance, what Facebook does. They have profiles of their users, and that's how they like to direct ads. Companies can so more efficiently place their ads via Facebook because there are consumer groups, and those, they get them. So I've listed like a few tools like Google Analytics, Google Remarketing, Facebook Insight, Facebook Pixels, also chatbots. and they're not all the same. The profiling is going deeper in some of them, and in some it's not. Facebook analytics usually is not a problem. Facebook pixel might be one. So I try to get into those social media plugins topics, and this is quite interesting because at present we have 2 cases pending with the European Court of Justice. I've listed them here. We don't have a ruling of the European Court of Justice yet, but in one of those cases, which is a German case, we have an opinion of the Advocate General. And to sum that up, the Advocate General says, or to give it the facts first, there was a German company. They offered like educational services, and they had a fan page on Facebook. Okay, and every one you click on Facebook, that fan page, the controller here, Wirtschaftsakademie, Facebook provided them with statistical data, what did they do, what did they next, so on, the users, which allowed Wirtschaftsakademie to optimize their marketing. But at the same time, it allowed Facebook to collect those data about their users and to enlarge their profiling about them. Now, Facebook has a problem because there are disputes whether what Facebook does is allowed under the GDPR and whether they provide enough transparency and things like these, and probably at the moment not. But the thing was now, German authority said, Wirtschaftsakademie, you're not allowed to do this fan page, because there is no information. And that went on to the European Court of Justice, and the Advocate General is of the opinion that it's not only Facebook who is the controller in that case, but also Wirtschaftsakademie. So that means Wirtschaftsakademie would have responsibilities as a controller under the GDPR, although the data are processed by Facebook, and Wirtschaftsakademie has no influence on Facebook how to do that. If you think back, controller is the one who defines the purposes and the means of the processing of data. And Wirtschaftsakademie has no control over Facebook. Nevertheless, the Advocate General said, you picked Facebook, even though you can't change their terms and conditions, they're compulsory, but still you picked them, you enabled that way of processing data, that profiling, because without opening a fan page, Facebook would not be able to do that. You can also stop it, remove your fan page. So in a way, you're a controller and you have obligations as a controller under the GDPR. They can be different from those of Facebook, but they are here. And if the European Court of Justice follows this opinion, which I believe is very likely, everyone doing this, having a Facebook, a fan page, or even having a social media plugin, because the other case I didn't mention was a social media plugin. It's the same thing, actually. Has to rethink its policy and probably has at least information rights. Thank you.